Welcome to the Law Clinic, where we break down complex legal issues in South Africa. I'm your host, Sanem Velasi, and on this channel, we will be exploring various legal concepts with a focus on civil procedure. From understanding your basics of court proceedings to analyzing your complex legal concepts, we will dive into all. Subscribe now and join me on this journey to demystify the law. Today, I'll be explaining what is meant by civil procedure. When we talk about civil procedure, this means the rules and the regulations which are used by the courts in governing civil disputes. When it comes to civil procedure, we break this down into two key concepts. We have what we term the motion proceedings and the action proceedings. However, when it comes to these two, we ordinarily use the commencing step as the letter of demand for both. What is meant by the letter of demand? A letter of demand is simply a document which is served on the other party as the initiating step in a civil dispute. I'm going to give a practical example. If you are an attorney representing an applicant who is owed R1,000,000 by the opponent, what you would simply do is to draft a letter wherein you stipulate the details of the firm representing the applicant. After that, you stipulate the details of the opponent. Thereafter, your opening ref would be demand for the immediate payment of R1,000,000. Thereafter, your opening line would be to stipulate that you're representing the applicant whose names are. After that, you stipulate the ID number. You furthermore briefly state how the dispute arose and how your client is being owed R1,000,000. You further stipulate if the applicant has tried to engage the opponent to no avail, if that was done. And thereafter, you stipulate and give the opponent a stipulated number of days to respond or to pay the amount. Should they fail to pay the amount, thereafter, you let them know that you will be commencing with legal proceedings. So the letter of demand, in essence, is the final step before you proceed to file court documents. One may ask if it is a prerequisite to serve a letter of demand, and the answer is no. However, it is always advisable to commence with serving a letter of demand. And the reason for this would be to safeguard the issue of costs. Ordinarily, in all proceedings, the applicant in motion proceedings would normally pay for costs. And should the applicant fail to initiate by serving a letter of demand, the court may refuse to award the applicant the cost that would have been ordinarily awarded in the matter. I think that's it for today. Should you not understand what a letter of demand is, please drop in a comment for me to explain further. Until next time, please don't forget to comment, like, and subscribe for more civil procedure content.